20 maximums in equity. Role of maximums. Maximums of equity are not a rigid set of rules, but are rather general principles which can be deviated from in specific cases. Equity will not allow a trust to fail for want of a trustee. If there is no trustee, however, whoever has legal title Whoever has legal title to the trust property will be considered the trustee. Otherwise, a court may appoint a trustee. In Ireland, the trustee may be an administrator of a charity to which a trust is related. Equity regards the beneficiary as the true owner. Due to the limits in old common law, no remedy was had for beneficiaries if, for example, a trustee ran off with the trust property. To remedy this and protect intended recipients of trust property, equity regards the beneficiary as the true eventual owner of the trust property. Snell's Equity and English treaties take the view of that the maxims do not cover the whole ground, and moreover, they overlap. One maximum contains by implication what belongs to another. Indeed, it would not be difficult to reduce all under two. Equity will not suffer a wrong to be without a remedy. And when we click on it and it opens up, it says, equity will not suffer a wrong to be without a remedy. When seeking an equitable relief, the one that has been wronged has the strong hand. The strong hand is the one that has the capacity to ask for legal remedy, judicial relief. In equity, this form of remedy is usually one of specific performance. Let me go back here. Oops. Bear with me. Let's get back in here. Equity will not suffer a wrong to be without a remedy, and equity acts on the person. When we look at equity acts on the person, maxims of equity are legal maxims that serve as a set of general principles or rules which are said to govern the way in which equity operates. They tend to illustrate the qualities of equity, in contrast to the common law, as a more flexible, responsive approach to the needs of the individual, inclined to take into account the parties' conduct of worthiness. They are developed by the English Court of Chancery and other courts that administer equity jurisdiction, including the law of trust. Although the most fundamental and time-honored of the maxims listed on this page are often referred to on their own as the maxims of equity or the equitable maxims. The first equitable maximum is equity delights in equity, or equity is equity. Like other kinds of legal maxims or principles, they were originally and sometimes still are expressed in Latin. List of maxims. 1. Equity sees that as done what ought to be done. 2. Equity will not suffer a wrong to be without a remedy. 3. Equity delights in equity. 4. One who seeks equity must do equity. 5. Equity aids the vigilant, not those who slumber on their rights. 6. Equity imputes an intent to fulfill an obligation. 7. Equity acts in personam or persons. 8. Equity arbors a forfeiture. 9. Equity does not require an idle gesture. 10. He who comes into equity must come with clean hands. 11. Equity delights to do justice and not by halves. 12. Equity will take jurisdiction to avoid a multiplicity of suits. 13. Equity follows the law. 14. Equity will not aid a volunteer. 15. Where equities are equal, the law will prevail. Now it's important to understand what that means. Where the equities are equal, the law will prevail. Well, that brings into question, what is the law? And let me articulate it to you quite simply. Contract makes the law, and equity follows the law. And when two people have mutually equitable interest in, or their equities are equal, then we revert back to the contract at hand in the first instance that created the law. Okay? 16. Between equal equities, the first in order of time shall prevail. So the first one to make their claim in equity shall prevail. 17. Equity will not complete an imperfect gift. 18. Equity will not allow a statute to be used as a cloak for fraud. 19. Equity will not allow a trust to fail for want of a trustee. And 20. Equity regards the beneficiary as the true owner. List of maximums. 1. Equity sees that as done what ought to be done. This maximum means that when individuals are required by their agreements or by law to perform some act of legal significance, equity will regard that acts as having been done as it ought to have been done. Even before it has actually happened, this makes possible the legal phenomenon of equitable conversion. Let's see what equitable conversion is. Equitable conversion is a doctrine of the law of real property under which a purchase of real property becomes the equitable owner of title to the property at the time he or she signs a contract binding him or her to purchase the land at a later date. The seller retains legal title over the property prior to the date of conveyance, but this land interest is considered personal property, a right to the payment of money rather than a right to property. The risk of loss is then transferred to the buyer. If a house on the property burns down after the contract has been signed but before the deed is conveyed, the buyer will nevertheless have to pay the agreed upon purchase price for the land unless the seller in possession or deemed in possession has failed to protect it. Such issue can and should be avoided by parties by stipulating in contract who will bear the loss in such occurrence. The above rule varies by jurisdiction, but is the general rule. Sometimes this is purchased as equity regards, sometimes this is phrased as equity regards as done what should have been done. The consequence of this maximum and of the equitable conversion are significant in their bearing on the risk of loss. And when we look at risk of loss is a term used in the law of contract to determine which party should bear the burden of the risk for damage occurring to the goods after the sale has been completed, but before delivery has occurred. Such consideration generally come into play after the contract is formed, but before buyer receives goods. Something bad happens. Under the Uniform Commercial Code, the UCC, there are 4 risk of loss rules in order of application. 1. Agreement. The agreement of the parties controls. 2. Breach. The breaching party is liable for any uninsured loss, even though breach is unrelated to the problem. Hence, if the breach is the time of delivery and the goods show up broken, then the breach rule applies risk of loss on the seller. Delivery by common carrier other than by seller. 1. Risk of loss shifts from seller to buyer at the time the seller completes its delivery obligation. 2. If the destination contract, FOB, buyer's city, then risk of loss is on the seller. 3. If it is a delivery contract, standard, or FOB, seller's city, then the risk of loss is on the buyer. 4. In cases not covered by the foregoing rules, if the seller is a merchant, then the risk of loss shifts to the buyer upon buyer's receipt of the goods. If the buyer never takes possession, then the seller still has the risk of loss. In bankruptcy law, the risk of loss rule under a contract can be abrogated by a secured interest. In transaction, when parties entered a contract for a sale of real property, and we'll go into real property here. Real property. In English common law, real property, real estate, realty, or immovable property is land which is the property of some person and all structures, and also improvements or fixtures integrated with or affixed to the land, including crops, buildings, machinery, wells, dams, ponds, mines, canals, roads, among other things. The term is historic, arising from a now discontinued form of action, which distinguished between real property disputes and personal property disputes. Personal property was and continues to be all property that is not real property. In countries with personal ownership of real property, civil law protects the status of real property in real estate markets, where estate agents work in the market of buying and selling real estate. Scottish civil law calls real property heritable property, and in French-based law, it is called immovable property. The buyer is deemed to have obtained an equitable right that becomes a legal right only after the deal is compelled. Due to his equitable interest, an equitable interest is an interest held by virtue of an equitable title, a title that indicates a beneficial interest in property and that gives the holder the right to acquire formal legal title or claimed on equitable grounds, such as the interest held by a trust beneficiary. The equitable interest in a right in equity that may be protected by an equitable remedy. This concept exists only in systems influenced by the common law tradition, such as New Zealand, England, Canada, Australia, and the United States. In the outcome of the transaction, the buyer who suffers a breach may be entitled to an equitable remedy. An equitable remedy are judicial remedies developed by courts of equity from about the time of Henry VIII to provide more flexible responses to changing social conditions than was possible in precedent-based common law. Equitable remedies were granted by the Court of Chancery in England and remain available today in most common law jurisdictions. In many jurisdictions, legal and equitable remedies have been merged, and a single court can issue either or both remedies. Despite widespread judicial merger, the distinction between equitable and legal remedies remains relevant in a number of significant instances. Notably, the United States Constitution's 7th Amendment preserves the right to a jury trial in civil cases over $20 to cases at common law. The distinction between types of relief granted by the courts is due to the courts of equity, such as the Court of Chancery in England, and still available in common law jurisdiction. Equity is said to operate on the consensus of the defendant. So an Equitable remedy is always directed at a particular person and person's knowledge. State of mind and motives may be relevant to whether a remedy should be granted or not. Equitable remedies are distinguished from legal remedies, which are available to a successful claimant as of a right by the discretion of the court to grant them. In common law jurisdiction, there are a variety of equitable remedies, but the principal remedies are injunction, specific performance, account of profits, rescission, recertification, equitable estoppel, certain proprietary remedies such as constructive trust, subrogation, in very specific circumstances, an equitable lien, equitable compensation, a point of removal of fiduciary, and interpleader. Of specific performance. Specific performance is an equitable remedy in law of contract, whereby a court issues an order requiring a party to perform a specific act, such as a complete performance of a contract. It is typically available in the sale of land, but otherwise and generally available in damages or an appropriate alternative. Specific performance is almost never available for contracts of personal service, although performance may be ensured through the threat of proceedings for contempt of court. Specific performance is commonly used for the form of an injunctive relief concerning confidential information of real property. While specific performance can be in the form of any type of forced auction, it is usually to complete a previous established transaction, thus being the most effective remedy in protecting the expectation interest of the innocent party to the contract. It is usually the opposite of prohibitory injunction, but there are mandatory injunctions that have a similar effect to specific performance. At common law, a claimant's rights were limited to an award of damages. Later, the Court of Equity developed the remedy of specific performance instead. Should damages prove inadequate, specific performance is often guaranteed through the remedy of the right of possession, giving the plaintiff the right to take possession of the property in dispute. As with equitable remedies, orders of specific performance are discretionary, so their availability depends on the appropriateness in the circumstances. Such order are granted when damages are not an equitable remedy, and in some specific case, such as land, which is regarded as unique. Although not always, see below. If he is successful in seeking remedy at law, he is entitled to the value of the property at the time of the breach, regardless of whoever it has appreciated or depreciated. The facts that the buyer may be forced to suffer a depreciation in value of the property means that he bears the risk of the loss. For example, the improvements of property he bought burned down while he is still in escrow. What is escrow? Being in escrow is a contractual agreement in which a third party, the stakeholder or escrow agent, receives and disperses money or property for the primary transaction parties, most generally used with plentiful terms that conduct the rightful action that follow. The disbursement is dependent on conditions agreed to by the transacting parties. Example include an account established by a broker for holding funds on behalf of the broker's principal or some other person until the consummation or termination of a transaction, or a trust account held in the borrower's name to pay obligations such as property tax and insurance premiums. The word derives from the Old French word escrow, escroue, meaning a scrap of paper or a scroll of parchment. This indicates the deed that a third party held until a transaction was completed. Problems may sometimes arise because through some lapse or omission, insurance coverage is not in force at the time of a claim is made. If the policyholder has clearly been at fault in this connection because, for example, he has not paid premiums when he should have, then it will normally be quite responsible for an insurer to decline to meet the claim. However, it gets more difficult if the policyholder is no more at fault than the insurer. The fair solution is the circumstance may be arrived at by applying the principles of equity regards that as done, that ought to be done. In other words, what would the position have been if what should have been done had been done? Thus, in one case, premiums on a life insurance policy were overdue. The insurer's letter to the policyholder warning him of the facts was never received by the policyholder, who died shortly after the policy consequently lapsed. It was clear that if the notice had been received by the policyholder, he or his wife would have taken steps to ensure the policy continued in force. Because the policyholder was terminally ill at the time of the coverage provided by the policy was something his wife was plainly going to require in a foreseeable future. Since the policyholder would have been fully entitled to pay the outstanding premium at this stage, regardless of his physical condition, the insurer, with some pursuance from the Bureau, agreed that the matter should be dealt with as if the policyholder had done so. In other words, his widow was entitled to the sum assured less the outstanding premium. In other similar cases, however, it has been possible to follow the same principle because there has not been sufficiently clear evidence that the policy would have been renewed. Another illustration of the application of this equitable principle was in connection with motor vehicle insurance. A policyholder was provided with the coverage of the basis that she was entitled to a no claims discount from her previous insurer. Confirmation to this effect from the previous insurer was required. When that was not forthcoming, her coverage was canceled by the brokers who had issued the initial coverage note. This was done without reference to the insurer concerned, whose normal practice in such circumstances would have been to maintain coverage and to require payment of full premium until proof of the no claim discount was forthcoming. Such proof was eventually obtained by the policyholder, but only after she had been involved in an accident after the cancellation by the brokers of the policy. Here again, the fair outcome was to look at what would have happened if the insurer's normal practice had been followed. In such circumstances, the policyholder would have plainly still had a policy at the time of the accident. The insurer itself had not acted incorrectly at any stage. However, in the circumstance, it was equitable for it to meet the claim. Equity will not suffer a wrong to be Equity will not suffer a wrong to be without a remedy. When seeking an equitable relief, the one that has been wronged has the strong hand. The strong hand is the one that has the capacity to ask for a legal remedy. What is a legal remedy, you might ask? A legal remedy is also judicial relief, or a judicial remedy. It means with which a court of law, usually in the exercise of civil law jurisdiction, enforces a right, imposes a penalty, or makes another court order to impose its will. In common law jurisdiction, a mixed civil common law jurisdiction, the law of remedies distinguishes between a legal remedy, ergo, specific amount of monetary damages, and equitable remedy, injunctive relief, or specific performance. Another type of remedy available in these systems is declaratory relief, where a court determines the right of the parties to an action without awarding damages or ordering equitable relief. In English and in American jurisprudence, there is a legal maximum. A Betty one sometime honored in the breach, that for every right there is a remedy. Where there is no remedy, there is no right. That is, lawmakers claim to provide appropriate remedies to protect rights. The legal maximum was enunciated by William Blackstone. It is a settled and invariable principle in the law of England that every right, when withheld, must have a remedy, and every injury its proper redress. Judicial relief. In equity, this form of remedy is usually one of specific performance, and we've already been over specific performance, or an injunction. What is an injunction? An injunction is a legal equitable remedy in the form of a special court order that compels a party to do or refrain from a specific act. When a court employs the extraordinary remedy of injunction, it directs the conduct of the party and does so with the backing of the full coercive powers. A party that fails to comply with an injunction faces criminal or civil penalties, including possible monetary sanctions and even imprisonment. They can also be charged with contempt of court. Counter injunctions are injunctions that stop or reverse the enforcement of the other injunction. Injunctive relief. These are superior remedies to those administrative at the common law, such as damages and Latin legal maxims. The Latin legal maximum, where there is a right, there must be a remedy, sometimes cited as abi juis ibi redimam. It's Latin. Not even going to try, guys. Not even going to try to read it. I'll pick up Hooked on Phonics. I'll learn Latin later. The maxims is necessarily subordinate to the positive principles and cannot be applied either to subvert established rules of law or to give the court a jurisdiction hereunto unknown. And it is only in general, not in literal senses, that maxims have force. Equity, delight in equity. Where two persons have an equitable right, the property will be divided equally. Thus, equity will presume joint owners to be tenants in common, unless the parties have expressly agreed otherwise. Equity also favors partition if requested of jointly held property. One who seeks equity must do equity. This is extraordinarily important. To receive equitable relief, the petitioning party must be willing to complete all of its own obligations as well. The applicant to a court of equity is just as much subject to the power of the court as the defendant. This maximum may also overlap with the clean hands maximum. Now, everybody wants to know what clean hands are, and you shall know it. Maximums of equity and legal maximums that serve as a set of general principles or rules which are said to govern the way in which equity operates. They tend to illustrate the qualities of equity. It in contrast to the common law as a more flexible, responsive approach to the needs of individuals, inclined to take into account the parties' conduct and worthiness. Okay, so you must conduct yourself properly, and you must be worthy of that remedy. Equity aids the vigilant, not those who slumber upon their rights. Pretty self-explanatory. Delays defeat equity. Equity aids the vigilant, not those who sleep upon their rights. Equity imputes an intent to fulfill an obligation. Generally speaking, near performance of a general obligation, and we'll get into obligation here. An obligation is a course of action that someone is required to take, whether legal or moral. Now, when we get into moral, ladies and gentlemen, that again is lending to the divine, the creator. And when we look at moral here, in moral philosophy, deontological ethics, or deontology, is the normative ethical theory that the morality of an action should be based on whether that action itself is right or wrong, under the series of rules rather than based on the consequences of the action. It is sometimes described as a duty or obligation. There are also obligations in other normative contexts, such as obligations of etiquette, social obligations, religious, and possibly in terms of politics, where obligations are requirements which must be fulfilled. These are generally legal obligations which can incur a penalty for non-fulfillment, although certain people are obligated to carry out certain actions for other reasons as well, whether as a tradition or for social reasons. Will be treated as sufficient unless the law requires perfect performance, such as in the exercise of an option. Text writers give an example of a debtor. What is a debtor? Let's look at it real quick. A debtor is an entity that owes a debt to another entity. The entity may be an individual, a firm, government, a company, or other legal person. The counterparty is called a creditor. When a counterpart of this debt arrangement is a bank, the debtor is more often referred to as a borrower. If X borrowed money from her bank, X is the debtor and the bank is the creditor. If X puts money in the bank, X is the creditor and the banker is the debtor. What are you doing when you deposit a promissory note? Are you putting money in the bank? Yes, you are. Are you the borrower or the creditor when you sign that promissory note, ladies and gentlemen? Leaving a legacy. Legacy, a will or testament, is a legal document by which a person, the testator, expresses their wishes as to how their property is to be distributed at death, and means one or more persons, the executor, to manage the estate until its final distribution. For the devolution of property not disposed of by will, see inheritance and see inheritance. Okay. To his creditor, and we know what a creditor is, but we're going to read it anyway. A creditor is a party, ergo a person, organization, company, or government that has a claim on the service of the second party. It is a person or institution to whom money is owed. Okay, creditor. Equal to or greater than his obligation. Equity regards such a gift. What is a gift? Let's look at what gift is. A gift or a presentment is an item given to someone without the expectation of payment or anything in return. An item is not a gift if that item is already owned by the one to whom it is given. Although gift giving might involve an expectation of reciprocatory or a gift in return. All right. As performance of an obligation, so the creditor cannot claim both the legacy and payment of the debt. Equity acts in personam, or persons. In England, there was a distinction drawn between the jurisdiction of the law courts and that of the chancery courts. Courts of law had jurisdiction over property as well as persons, and their coercive powers arose out of their ability to adjust ownership rights. Courts of equity had power over persons. Their coercive power arose from the ability on authority of the crown to hold a violator in contempt. and take away his or her freedom or money until he or she purged himself or herself of his or her contumacious behavior. This distinction helped preserve and separation of powers between the two courts. Nevertheless, courts of equity also developed a doctrine that an applicant must assert a property interest. This was a limitation on their own power to issue relief. This does not mean that the courts of equity had taken jurisdiction over property. Rather, it means that they came to require that the applicant asserts a right of some significant substance as opposed to a claim for relief based on an injury to mere emotional or dignitary interest. Equity arbors a forfeiture. Today, a mortgagor refers to his interest in the property as his equity. The origin of the concept, however, was actually a mirror image of the current practice. At common law, a mortgage was a conveyance of the property, with a condition subsequent that if the grantor paid the secured indebtedness to the grantee or on or before the date certain, the law day, then the conveyance would be void, otherwise to remain in full force and effect, as was inevitable. Debtors would be unable to pay on the law day, and if they tender the debt after the time had passed, the creditor owed no duty to give the land back. So then the debtor would run to the court of equity, plead that there was an unconscionable forfeiture about to occur, and beg the court to grant an equitable decree requiring the lender to surrender the property upon payment of the secured debt with interest to date. And the equity court granted these petitions quite regularly and often without regard for the amount of time that had lapsed since the law day had passed. The lender could interpose a defense of latches, saying that, and let's go see what latches are, because I don't think anybody's paying attention to latches, and that's important. Latches refers to the lack of diligence and activity in making a legal claim or removing forward with legal enforcement of a right, particularly in regards to equity. Hence, it is an unreasonable delay that can be viewed as prejudicing the opposing defending party when asserted in litigation. It is an equity defense, that is, a defense to a claim for an equitable remedy. The person invoking latches is asserting that an opposing party has slept on its rights, and that, as a result of this delay, circumstances have changed. Witnesses or evidence may have been lost or no longer available, etc., such that it is no longer a just resolution to grant the plaintiff's claim. Latches is associated with the maximums of equity. Equity aids the vigilant and not the sleeping ones. That is, those who sleep on their rights. Put another way, failure to assert one's rights in a timely manner can result in a claim being barred by latches. So, in court, when they're asking you questions, or you have a objection that needs to be made on or for the record, and they stifle you from that, what they're seeking to do is hook you up with latches. The time has lapsed, the issue is passed, it's not on the table anymore. If you don't substantiate your claim, then you waive your claim. You waive your rights, okay? Saying that so much time had gone by and so many improvements and betterment had taken place, that would be inequitable to require undoing the finality of the mortgage conveyance. Other defenses, including equitable estoppel. Equitable estoppel, we're going to go look at this real quick. An equitable estoppel is a judicial device in the common law legal system whereby a court may prevent or stop a person from making assertions or from going back on his or her word. the person being sanctioned is estopped. Estoppel may prevent someone from bringing a particular claim. Legal doctrines of estoppel are based in both common law and equity. It is also a concept in international law, where used to bar redemption as well. This unsettling system had a negative impact on the willingness of lenders to accept real estate as collateral security for loans, since a lender could not resell the property until it had been in uncontested possession for years, or unless it could show changed circumstances. The value of real estate collateral was significantly impaired, that is, until lawyers concocted the bill of foreclosure, whereby a mortgage could request a decree that unless the mortgagor paid the debt by a date certain and after the law date set in the mortgagor would thereafter be barred and foreclosed of a right, a title, an equity of redemption in and to the mortgage premises. What's an equity of redemption? Let's go look. The equity of redemption refers to the right of a mortgagor in law to redeem his or her property once the debt secured by the mortgage has been discharged. Let's look at title real quick here. Title, the property law. A title is a bundle of rights in a piece of property in which the party may own either a legal interest or equitable interest. The rights in the bundle may be separated and held by different parties. It may refer to a formal document, such as a deed, that serves as evidence of ownership. Conveyance of the document may be required in order to transfer ownership in the property to another person. Title is distinct from possession, a right that often accompanies ownership but is not necessarily sufficient to prove it. In many cases, possession and title may each be transferred independently of the other. For real property, land registration and recording provide public notice of the ownership information. All right. To complete the circle, one needs to understand that when a mortgagor fails to pay an installment when due, the mortgagee accelerates the mortgage, requiring immediate repayment of all entire mortgage indebtedness. The mortgagor does not have a right to pay the past due installments and have the mortgage reinstated. In Gaff versus Hope Building Co., the New York Court of Appeals observed that in such a case there was no forfeiture, only the operation of a clause fair on its face, to which the mortgagor had freely assented in the latter 20th century. New York lower courts eroded the Gaff doctrine to such a degree that it appears that it is no longer the law, and that a court of conscience consciousness has the power to mandate that a default be excused if it is equitable to do so. Of course, now that the pendulum is swinging in the opposite direction, we can expect courts to explain where the limits on the newly expanded equity of redemption lie. And it is probably not a coincidence that the case that have eroded Gaff versus Hope Building Corp. have been accompanied by the rise of arbitration. What is arbitration? Everybody speaks of it, but nobody's explaining it to you. Let's go into arbitration. Arbitration, a form of alternative dispute resolution, is a way to resolve disputes outside the courts. Now, a lot of people are trying to bring things into the court, and so often I'm seeing their cases are being discarded for a claim for which relief cannot be granted. And I firmly believe that one of the reasons that relief cannot be found in the court is because you haven't executed your remedies on the private side before you went to the public to find remedy and equity. And what I mean by that is you haven't exercised all your remedies through arbitration and a private administrative process in order to bring your subject matter before a court of competent jurisdiction. So it's important to understand what arbitration is. A form of alternative dispute resolution where you are trying to settle your dispute in the private, on the private side, absent of the public's assistance with a court. And that's just my belief through my studies and my research. Correct me if I'm wrong. There's a lot of avid readers and knowledgeable people out there, and again, I have an open mind. The disputes will be decided by one or more persons, the arbitrators, arbiters, or arbitral tribunal, which renders the arbitration award. An arbitration award is legally binding on both sides and enforceable in the courts. Arbitration is often used for the resolution of commercial disputes, particularly in the context of international commercial transactions. In certain countries, such as the United States, arbitration is also frequently employed in the consumer and employment matters, where arbitration may be mandated by the terms of employment of commercial contracts and may include a waiver of the rights to bring a class action claim. Mandatory consumer and employment arbitration should be distinguished from consensual arbitration, particularly commercial arbitration. Arbitration can be either voluntary or mandatory, although mandatory arbitration can only come from a statute or from a contract that one party imposes on the other, in which the parties agree to hold all existing or future disputes to arbitration, without necessarily knowing specifically what disputes will ever occur, and can be either binding or non-binding. Non-binding arbitration is similar to mediation in that a decision cannot be imposed on the parties. However, the principal distinction is that whereas a mediator will try to help the parties find a middle ground on which to compromise, the non-binding arbiter remains totally removed from the settlement process and will only give a determination of liability and, if appropriate, an indication of the quantum of damage payable. By one definition, arbitration is binding and non-binding arbitration is therefore technically not arbitration. Arbitration is a proceeding in which a dispute is resolved by an impartial adjudicator whose decisions the parties to the dispute have agreed or legislation has decreed will be final and binding. There are limited rights of overview and appeal of arbitration awards. Arbitration is not the same as judicial proceedings, although in some jurisdictions, court proceedings are sometimes referred to as arbitration, alternative dispute resolution, expert determination, mediation, or a form of settlement negotiation facilitated by a neutral third party. That's arbitration, ladies and gentlemen. And where were we at here? As a means for enforcing mortgages, equity does not require an idle gesture. Also, equity will not compel a court to do a vain and useless thing. It would be an idle gesture for a court to grant reformation of a contract and then to deny to the prevailing party an opportunity to perform it as it is modified. Reforming contract. Recertification is a remedy whereby a court orders a change in a written document to reflect what is ought to have said in the first place. It is an equitable remedy, which means the circumstances where it can be applied are limited. In the United States, this remedy is commonly referred to as reformation. Number 9, he who comes into equity must come with clean hands. It is so often stated that one who comes into equity must come with clean hands. Or, alternatively, equity will not permit a party to profit by his own wrong. In other words, if you ask for help about the action of someone else but have acted wrongly, then you do not have clean hands, and you have not received the help you seek. For example, if you desire your tenant to vacate, you must have not violated the tenant rights. However, the requirements of clean hands does not mean that a bad person cannot obtain the aid of equity. Equity does not demand that it is suitors shall have led blameless lives. The defense of unclean hands only applies if there is a nexus between the applicant's wrongful act and the right he wishes to enforce. For instance, in Riggs versus Palmer, a man who had killed his grandfather to receive his inheritance more quickly, and for fear that his grandfather may change his will, lost all right to the inheritance. In D&C Builders Ltd. versus Rees, R-E-E-S, a small building firm did some work on the house of a couple named Rees. The bill came to 732 euros, of which the Rees had already paid 250 euros. When the builder asked for the balance of 482 euros, the Rees announced that the work was defective and they were only prepared to pay 300 euros. As the builders were in serious financial difficulties, as the Rees knew, they reluctantly accepted the 300 euros. In completion of the account, the decision to accept the money would not normally be binding into contract law, and afterwards the builders sued the Rees for the outstanding amount. The Rees claimed that the court should apply the doctrine of equitable estoppel, which can make promises binding when they would normally not be. However, Lord Dinning refused to apply the doctrine on the grounds that the Rees had taken unfair advantage of the builders' financial difficulties and therefore had not come with clean hands. Equity delights to do justice and not by halves. When a court of equity is presented with a good claim to equitable relief, and it is clear that the plaintiff also sustained monetary damages, the court of equity has jurisdiction to render legal relief, ergo monetary damages. Hence, equity does not stop at granting equitable relief, but goes on to render a full and complete collection of remedies. 11. Equity will take jurisdiction to avoid a multiplicity of suits. Thus, where the court of equity has all the parties before it, it will adjudicate upon all of the rights of the parties connected with the subject matter of the action, so as to avoid a multiplicity of suits. This is the basis of the procedures of interpleader class action and the more rarely used bill of peace. And I am curious about the interpleader. Interpleader is a civil procedure that allows a plaintiff or a defendant to initiate a lawsuit in order to compel two or more other parties to litigate a dispute. An interpleader action originates when the plaintiff holds property on behalf of another, but does not know to whom the property should be transferred. It is often used to resolve disputes arising under insurance contracts. Let's go back here and look at Bill of Peace. A Bill of Peace was an English court practice used in the 17th and 18th century for legal disputes involving multiple parties that shared common aspects. It allowed the English Court of Chancery to settle the rights of parties, a group known as the multitude, in one suit in equity court. If the equity court allowed the matter to proceed as a bill of peace, the result of the suit would bind all members of the multitude, whether they actually appeared in the courts or not. There you go. Equity follows the law. This maxim also expressed as, and again it goes into Latin, which means more fully that equity will not allow a remedy that is contrary to the law. The Court of Chancery never claimed to override the courts of common law. Story states where a rule either of the common or the statute law is direct and governs the case with all its circumstances or a particular point, a court of equity is such bound by its as a court of law, and can as little justify a departure from it. According to the Udmund Henry Turner Snell, it is only when there is some important circumstance disregarded by the common law rules that equity interferes. Cardozo wrote in his dissent in Graff versus Hope Building Corporation, 254, NY 1 at 9 in 1930. Equity works as a supplement for law and does not supersede the prevailing law. Equity will not aid a volunteer. Equity cannot be used to take back a benefit that was voluntarily but mistakenly coffered without consultation of the receiver. This maximum protects the doctrines of choice. This maximum is very important in restitution. Restitution develops as a series of writs called special assumpsit, which were later additions in the courts of law and were more flexible tools of recovery based on equity. Restitution could provide means of recovery when people bestowed benefits on one another, such as giving money or providing services. According to contracts, that would have been legally unenforceable. However, pursuant to the equitable maximum, restitution does not allow a volunteer of officis intermeddler to recover. A volunteer is not merely someone who acts selflessly in the legal and equitable context. It refers to someone who provides a benefit regardless of whether the recipient wants it. For example, when someone mistakenly builds an improvement on a home, neither equity nor restitution will allow the improver to recover from the homeowner. An exception to this maximum can be seen in case where the doctrine of Estoppel applies. Where equities are equal, the law will prevail. Equities will provide no specific remedies where the parties are equal or where neither has been wronged. The significance of this maximum is that the application to the chancellors often did so because of the formal pleading of the law courts and the lack of flexibility they offered to litigants. Law courts and legislators, as lawmakers, through the limits of the substantive law they had created, thus calculated a certain status quo that affected private conduct and private ordering of disputes. Equity, in theory, had the power to alter the status quo, ignoring the limits of legal relief or legal defense. But courts of equity were hesitant to do so. This maximum reflects the hesitancy to upset the legal status quo. If in such a case the law created no cause of action, equity would provide no relief. If the law did provide relief, then the application would be obligated to bring a legal rather than an equitable action. This maximum overlaps with the previous mentioned one. Equity follows the law. 15. Between equal equities, the first in order of time shall prevail. This maximum operates where there are two or more competing equitable interests. When two equitable or equal the original interest, i.e., the first in time, will succeed. 17. Equity will not complete an imperfect gift. If a donor has made an imperfect gift, i.e., lacking the formalities required by common law, equity will not assist the intended donee. This maximum is a subset of equity will not assist a volunteer. Note, the exception in Strong versus Byrd, 1874, LR 18 EQ 315. The donor appoint the intended donee as executor of his/her will, and the donor subsequently dies. Equity will perfect the imperfect gift. 18. Equity will not allow a statute to be used as a cloak for fraud, which is what they're doing in your courts every day. Equity prevents a party from relying upon an absence of a statutory formality if to do so would be unconscionable and unfair. This can occur in secret trust and also constructive trust and so on. What's a constructive trust, ladies and gentlemen? I think it's important for you to know because it's what they do to you in a traffic citation. A constructive trust is an equitable remedy resembling a trust, implied trust, imposed by a court to benefit a party that has been wrongfully deprived of its rights. So, in the court, in an instance of a traffic citation, they're alleging that the state is the injured party and they've been wrongfully deprived of their rights, but we know states don't have rights. We know the state is a fiction. So everything that they're doing to you in this constructive trust is why it's important for you to appoint them as trustee and let them lay in their own misery. Let them lay in their own menagerie of crap that they created, because they're the ones that ultimately have a fiduciary duty to offset, discharge, and return to you, the beneficiary, all the proceeds left over with a full accounting to make sure that the prosecutor paid his taxes. Okay? Hate to go off on that little tangent, but I think it was needed. 19. Equity will not allow a trust to fail for want of a trustee. This is extraordinarily important. If there is no trustee, whoever has legal title to the trust property will be considered the trustee. Otherwise, a court may appoint a trustee. In Ireland, the trustee may be an administrator of a charity to which the trust is related. And 20. Equity regards the beneficiary as the true owner. See also English trust law, brocard law, legal maximums, list of legal Latin terms. Source of maximum material below. The free dictionary link. Maximum. Redirected from equity aids the vigilant, not those who slumber on their rights. Also found in dictionary thesauruses, medical encyclopedias, and Wikipedia. I am going to stop there. I mean, this is a 20-page document. I'm at page 10. We went through 20 maxims of law. I hope that helps you guys. It's got to be 5 or 6 in the morning. I'm ready to catch a couple hours of sleep. Thank you for joining me. Maximums of equity and maxims of law are extraordinarily important. They're the very foundation of what law was built upon. And the principles and the concepts of maxims of law will so often lead you to victory as long as you come with clean hands. So make sure that your intentions are always pure. Remember that contract creates the law and equity follows the law. It's very important. We live in a lawless society in North America. There are no laws. Contract creates the law. So if you don't have a contract before the court, then there is no law and there's nothing to bind you to. Because after 1933, everything has been broken down into contract. The obligations are the obligations always of the United States, because the United States borrowed our wherewithal in order to conduct business because politicians had shamelessly run our great nation into the ground. And they continue to do so to this day by abducting our children, selling them off as sex slaves, the erroneous and heinous things that they have done. You look at Obama, who's given $1.8 billion of physical FRN notes to Iran, a country that we were trying to stop from making nuclear weapons at one point. But yet we give them $1.8 billion of physical cash. Absolutely asinine, untraceable physical cash. Nobody's in jail. Hillary Clinton, obscene videos of her molesting children. Bill Clinton with this Epstein thing. I mean, you guys really need to start paying attention to your leaders or the people that you perceive to be leaders and realize that they're educating your children. I wouldn't let these scoundrels train my dog, let alone be around my offspring. It's just unthinkable to even think that we would allow these people to dictate what we know to be true and correct and good in life. Follow the Creator, all glory goes to God, and remember, pay attention to the people that you worship and idolize. Because I'm telling you right now, I see a lot of people that want to be Democrat and Republican, and I don't care what party they are, they're all corrupt. Every last one of them is usurping energy and power from you because they're lazy and couldn't do anything if their life depended on it. They don't know how to build houses. They don't know how to grow farms. gardens. They don't know how to manage farms. They don't know how to take care of real estate. They wouldn't know how to slaughter an animal if they needed to eat and fend for themselves. All these people feed off the backs of knowledgeable, intelligent men and women who have asserted themselves in their lives and gained a set of skills that are productive in society. What they are doing is fleecing you. What you do is productive. What they do is rob Peter to pay Paul. And they're always doing it. It's a Ponzi scheme. They're always stealing from you. And you're getting nothing in return. And they guise it as though what they are doing is some type of benefit to you. Let me ask you this. If you could keep your whole paycheck in its entirety, how much would you gain a month? If you weren't out there registering your car, which is gifting it to the state, which then you fall underneath the guidelines of having to pay rent fees or taxes to utilize your own property, how much could you save and how much could go to your offspring in the future? What would you be able to leave behind if you weren't being extorted all your energy? Because in the end, ladies and gentlemen, it's not about money. It's not about gold. It's not about silver. It's about quality of life and energy. Time is the most valuable resource in the world. You only have so many heartbeats before you're gone. So use them wisely. Have an ascension of the mind. Gain the knowledge it takes to be free. Come together. Work locally in your communities to create food banks. Don't be dependent on the government. The benefit they give you is like this, and what they take is like this. Okay? It's not an equal trade. It's not a fair trade. And you didn't realize it, but you were subjected to involuntary servitude from the time you were born because of the lack of education your mother and father had. I can assure you, the elites of the elite, their offspring learn what I'm teaching you today. So thank you for your time. All the glory goes to the Creator, and I hope you guys have a blessed day.